The International Criminal Court is now in session. L'audience dans le Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning to everybody. Could the court office please call the case?
Good morning, Mr. President, Your Honors. Situation in the Islamic Republic of Afghanistan. Situation reference ICC 0217. And for the record, we are in open session.
Thank you. May I ask for indication as to whether any person present in the courtroom today is appearing for the first time? If so, may this person kindly introduce themselves? Yeah. Please.
Good morning, Your Honours. For Global Rights Compliance, I'm Ian Edwards, replacing Wayne Jordash, QC.
Thank you very much. Someone else? Thank you very much. For the record, then, I note that all appearances of participants have been placed on the record. In line with the amended schedule for today's proceedings, the Peace Chamber will begin this session by continuing to hear the submissions from the remaining amici curiae on the merits of the appeal. Following the last request of the legal representatives of victims yesterday, the Peace Chamber has decided to permit each group of legal representatives of victims to make final representations in the second session, as indicated in the amended schedule that will be provided to you by the court officer. In addition, the Chamber has just been notified that Mr. Paweł Wieliński, for reasons beyond his control, will not be able to attend the hearing today. We regret this circumstance. The Peace Chamber notes that the amici from the European Centre of Law and Justice filed this morning a request for leave to file a written submission in response to the submissions of the LRVs. The Peace Chamber does not find it necessary for the proper determination of the issues on appeal to receive further submissions from the amici. The request is therefore rejected. I now invite the Afghanistan Human Rights Organization to address the Peace Chamber on the merits on the appeal. Your 15 minutes begins now.
Thank you, Mr. President. Good morning, Mr. President. Good morning, Your Honors. The reality is that Afghanistan is still in war. The infrastructure of the country is destroyed. Hundreds of thousands, and by some estimates, millions of lives have been killed. Many more have been wounded and disabled, and many more have been displaced in the country or become refugees. The reality is that conflict has turned Afghanistan into a breeding ground for fundamentalist and extremist groups and a battleground for regional and international powers. The reality is that there are no discussions concerning justice and accountability as part of the United States negotiations with the Taliban. The reality is that in over 40 years of conflict and violence, none of the major leaders of international crimes have ever been investigated or brought to justice. The reality is that despite the justice initiatives mentioned by the representatives for the Afghan government, only a handful of low-level perpetrators have been prosecuted, the War Crimes Unit is largely defunct, and perpetrators continue to operate with near impunity in Afghanistan. The reality is that peace first, then justice, has been a promise told to Afghan victims for the past 40 years and has resulted in neither peace nor justice. Your Honors, when considering the current situation in Afghanistan, it is inconceivable that an investigation into these atrocities would not be in the interests of justice. Pretrial Chamber 2 drew the opposite conclusion by contorting the notion of justice and speculating on what Afghan victims want. And in doing so, the pretrial chamber not only erred as a matter of law and fact, it abandoned the court's mandate towards the Afghan people. And we ask that this court not make the same mistake. Today, Your Honors, I intend to address how the pretrial chamber erred by 1, misunderstanding what victims want, 2, misconstruing the notion of justice, especially in the context of Afghanistan. And finally, I will comment on the government's position and why you should not allow it to prevent the opening of an investigation. As I explained on Wednesday, the pretrial chamber failed to effectively ensure victim representation. But beyond that, the chamber also failed to sincerely and genuinely consider the opinion of Afghan victims who did make representations. Fundamentally, Your Honors, the pretrial chamber presumed that victims would be against an ICC investigation due to its belief that an investigation was unlikely to result in the arrest and prosecution of a suspect. In the chamber's own words, and I quote, "Victims' wishes and aspirations that justice be done would result in creating frustration and possibly hostility vis-a-vis the court," end quote. That's paragraph 96 of their judgment. This passage is uncited, this passage is unreasoned, and this passage amounts to pure speculation. At no point during the victims' representation process were victims ever asked whether they would support an investigation absent high chances of success. And you can see that as a matter of fact in the victim representation form, which we have provided you in tab 2 of your binders. Rather, victims were simply asked whether they would, quote, "want the ICC prosecutor to investigate the violence associated with the conflict in Afghanistan since May 2003, end quote. And to that question, 680 of the 695 respondents said yes. There is no doubt that had the pretrial chamber genuinely asked Afghan victims of war whether they would support an investigation, even in the absence of high chances of arrest and prosecution, that the resounding response would have been yes. And that fact, Your Honors, is evidenced in the declarations we have provided you and which are referenced on pages 17 to 20 of our table of authorities. For instance, one civil society leader in Afghanistan explained that he spoke with over 700 Afghan victims and that, and I quote, "Every person I spoke with supported an ICC investigation. They supported an ICC investigation even if the prospects of an arrest were low," end quote. And Your Honors, that's tab 6, paragraphs 9 to 10. Nothing in the record justified the pretrial chamber's speculative assertion that victims would not want an investigation under the circumstances. The record, and indeed the evidence, points firmly to the contrary. This leads me to my next point. The pretrial chamber also erred in its understanding of justice under Article 53(1)(c). Your Honors, my colleagues have very forcefully and very eloquently explained why the notion of justice under Article 53 is broader than effective investigations and subsequent prosecution of cases. So I'll instead focus on how Afghan victims believe that justice includes other dimensions, including truth, public accountability, and reversing a culture of impunity. And for this, again, I draw your attention to the declarations we have submitted to you by former high-level government officials and civil society leaders who collectively have interacted with hundreds of thousands of Afghan war crime victims. These individuals, Your Honors, as you can see for yourselves, uniformly share the conclusion that Afghan victims believe that an investigation would serve the interests of justice even in the absence of arrests and prosecutions. As noted by one former government official and civil society leader, he and his team spoke to and heard from thousands of Afghan victims of war with regards to the importance of an international investigation into crimes committed in Afghanistan. In his own words, and I quote, "Uniformly, Afghan victims of war support an ICC investigation into crimes committed in Afghanistan," end quote. And among the reasons for that support, he cites that the Afghan judicial system is still developing, and Afghan victims see, quote, "the ICC as an objective, unbiased forum for justice," end quote. And he notes that, and I quote again, "Afghan victims don't anticipate the ICC would solve all their problems, but they do see the ICC as a mechanism that would work on the issue of actually addressing war crimes," end quote. Your Honors, that's in tab 3 of your binders. Likewise, all of the over 100 individuals surveyed by NGOs on the ground about the pretrial chamber's decision conveyed that they would support an investigation even absent arrest and prosecution. And while the reasons they gave were varied, I wish to take this time just to highlight a few. One female victim who had lost her son in a truck bombing by a terrorist group in 2017 told us, and I quote, "I want war crimes to be investigated, and it is worth even temporary chaos and bringing peace and security," end quote. Her case, Your Honors, was never investigated. Another mother who lost her son in the same bombing in 2017 told us, and I quote, "Justice means a peace where no mother ever loses a child," end quote. Her case was never investigated. Another woman who lost her daughter after an attack on the Afghan Supreme Court by the Taliban in 2017 told us, and I quote, "An investigation will show people that their sacrifices are considered and not forgotten," end quote. Her case was never investigated. And finally, Your Honors, another victim told us, and I quote, "We can't bring back our dead. We can't regain what we have lost, but we can raise our voices and preserve the truth so people don't suffer the same in the future. And maybe we can gain some peace from being heard and acknowledged," end quote. Your Honors, her case was also never investigated. Overall, the reasons provided in our confidential declarations for why an investigation would serve the interests of justice are many. But at its heart, they concern the reality that Afghanistan has suffered 40 years of active combat. Who did what and when is unclear. Perpetrators continue to hold high social and governmental positions. Amnesty deals are an unfortunate reality, and people of Afghanistan yearn for a neutral, independent investigation. They reflect the hope of victims to have their suffering be acknowledged so that the record may be set straight, that perpetrators may be named and shamed, and that a fuller accounting of what has happened in Afghanistan can be brought to light, and so that a culture of accountability can be cultivated. Your Honors, no one is more sophisticated about the realities of how difficult it will be for individuals to be arrested and prosecuted than Afghan victims themselves. They are the ones who have lived for 4 decades and have watched amnesty deal after amnesty deal. They know that an arrest and prosecution will be difficult. But they also know that no action by the only court with jurisdiction other than the Afghan national courts will mean even more impunity, where Afghans will continue to be victimized, abused, and killed. And this takes me to my last point. The representatives from the Afghan government suggest that the ICC not investigate, watch what happens, and then decide later if it should intervene. We propose the inverse. This court should immediately authorize an investigation. The Afghan government can identify the specific cases it wishes to challenge under the statute's admissibility provisions, and the court can strike from the prosecution's investigation those cases that are being genuinely and appropriately pursued. As it stands right now, however, there is no reason to wait. While the government has recently made legal reforms, the written law unenforced is of little practical consequence to Afghan victims who have been suffering for decades and suffer to this day. Your Honors, we have provided you a declaration by a rule of law expert who specifically focused on precisely the justice sector reforms identified by the government's representatives in their submissions. That's in tab 5 of your binders. She researched the Attorney General's War Crimes Unit, and she concluded that the office is staffed with, and I quote for you, new graduates who lack experience investigating or prosecuting war crimes, end quote. She was also informed that a United Nations project to help with capacity building of that very office had been canceled, and that when she had asked why, she was told, and I quote, that it was no longer a funding priority, end quote. That's tab 5, paragraph 6 to 7. Her statement, Your Honors, was from July of this year. We have also provided you declarations from former high-ranking Afghan government officials who held their respective positions in the past 5 years. That's tabs 3 and 4 of your binders. You know who they are, you see who they are, you see their seniority, you can see how they were focused specifically on the justice sector and are intimately aware of how the judiciary works. Both concluded that the Afghan government is not capable of effectively prosecuting these crimes and that the ICC should open investigation. Let me quote from them, Your Honors. One states,
Excuse me, you have 2 minutes left.
thank you very much. One states in his September 2019 statement that, and I quote, the Afghan justice system is improving, but it is still very weak, and they don't have the capacity to undertake the types of investigations the ICC is capable of. The system is also susceptible to interference by the Afghan government, the Taliban, or outside forces, meaning that justice will not be delivered in an unbiased or objective manner, end quote. Let me quote from another former government official from his statement just last month, quote, for 4 decades, every sitting Afghan government has failed to provide justice for Afghan victims of war. None of the government investigations have produced any viable and reliable results. The Afghan government will not be able to bring any measure of justice for the Afghan people anytime soon. The country is still existing in a political dust storm. If left to the authorities alone, the human rights violators and murderers will long be dead by the time the crimes are addressed, and their victims will have lost their chance at justice, end quote. Finally, you have the statements of civil society leaders who have interacted with tens of thousands of Afghan war victims. All of them tell you that the government is not able to effectively prosecute these crimes for a variety of reasons, not including the government's strength vis-a-vis various armed groups and other interested states. Your Honors, to conclude, the Afghan people are strong and they will persevere, but part of their path intertwines with this court. They are in this moment turning to you to provide a path that includes justice and accountability. We ask you to not sacrifice this court's mandate for politics. We ask you to not sacrifice the hopes of Afghan victims for political expediency. This concludes our submissions. We thank you for your time.
Thank you, Counsel, very much. Now, I would invite the former UN Specialist Reporter, Mr. Gary. You are invited to address the Chamber. 15 minutes. Begins now. Please proceed.
Good morning, Mr. President, Your Honors. Thank you for the privilege of making these amicus curiae submissions before you today. These submissions are made in my personal capacity and on behalf of the former UN Special Rapporteurs on torture and other cruel, inhumane, and degrading treatment or punishment, namely Professor Manfred Nauick at the University of Vienna and Juan Mendez at American University, Washington College of Law, who himself is a torture survivor and named prisoner of conscience by Amnesty International, as well as the former UN Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence, Professor Pablo de Greff at New York University School of Law. The former UN Special Rapporteurs deeply regret that prior commitments prevent them from appearing in person before you today. By way of overview, Amici contend that pretrial Chamber 2 erred on the merits of its decision of 12 April 2019 when it failed to authorize the prosecutor's Article 15 request for an authorization of an investigation into the situation in Afghanistan. This is because its interpretation and application of law therein was inconsistent with internationally recognized standards of human rights law in violation of Article 21(3) of the Rome Statute. For the specific reasons that follow, Amici urge this chamber to reverse, thereby authorizing an investigation without further delay. First, in the impugned decision, pretrial Chamber 2 was satisfied that there is a reasonable basis to believe that as of 1st May 2003, Afghan national security forces widely practiced torture in Afghan government detention facilities, and members of the US Armed Forces and the CIA committed the war crimes of torture and cruel treatment, outrages upon personal dignity, and rape, and other forms of sexual violence pursuant to a policy approved by US authorities. The chamber correctly found that these incidents fall within the subject matter jurisdiction of this court as a war crime, and Amici contend that they may also qualify as crimes against humanity under Article 7 of the Rome Statute. In addition, the chamber rightly found that these incidents are admissible because of, quote, the gravity per se of the crime of torture, and the circumstances that the conducts have allegedly been committed by public officials in their functions, unquote. Amici underscore the pretrial chamber's statement that torture is, quote, radically banned by international law, unquote, and that no derogation is permitted, even in times of armed conflict or terrorist attacks. This absolute prohibition is necessary for protecting the inherent dignity and integrity of all human beings, victims as well as potential perpetrators. Afghanistan and the United States are bound to abide by this jus cogens prohibition under customary and treaty law, specifically the United Nations Convention Against Torture, the CAT, the International Covenant on Civil and Political Rights, the ICCPR, and Common Article 3 of the 1949 Geneva Conventions. As a jus cogens prohibition, no state may enter into agreements for contracting around it, given the fundamental values it upholds. Second, under Articles 5 through 8 of the CAT, all states have an obligation to criminalize, investigate, prosecute, and punish torture wherever it occurs under the principle of aut dedere, aut judicare. Similarly, under the Rome Statute, where torture amounts to a war crime or crime against humanity, it is the duty of every state to exercise criminal jurisdiction over those responsible for international crimes under this statute. There is no discretion to address the breach otherwise. Here, as found by the pretrial chamber, not one state with criminal jurisdiction over the incidents alleged in the prosecutor's request since 2003 has been able to exercise it, and therefore, the investigation is admissible under the complementarity principle. While it is true that this finding was made on the basis of information available at the time of the prosecutor's request in 2017, the further information provided by the government of Afghanistan in these proceedings does not call the chamber's conclusion into question. It still remains, as noted by the chamber, that no national investigations have been initiated with respect to the prosecutor's request because, I emphasize, the request pertains to those who appear most responsible for alleged crimes. The same is true for the United States, and as noted by the pretrial chamber, both countries have focused thus far on cases limited to direct perpetrators or their immediate superiors. That said, Amici recall under the jurisprudence of this court that admissibility is an ambulatory process. Amici welcome both Afghanistan and the United States, or any other state, informing the prosecutor as soon as possible of any progress made by national authorities, initiating an investigation against those most responsible for torture in Afghanistan. given that the prosecutor will have to continue revisiting the issue. Because no such information has been made available at this stage, however, this appeals chamber should not find that the pretrial chamber erred in the impugned decision with respect to its finding that an investigation by the prosecutor would be admissible under complementarity.
Excuse me, Counsel.
Third.
I would like to ask you to slow down a little bit because of the
Yes,
interpretation.
thank you, Your Honor.
Thank you.
Third, failure by states to initiate a prompt criminal investigation, as is the case here, is itself a de facto denial of the rights to an effective remedy, reparations, and redress to victims of torture under the CAT and the ICCPR, as well as customary international law. Further, as stated by the UN High Commissioner for Human Rights and the Human Rights Council, it is a denial of the related rights to seek truth and accountability in the face of gross and systematic violations of human rights available to victims and society in the face of institutional policies enabling their occurrence. Criminal investigation is a necessary means to guarantee these rights and avoid recurrence of torture. As noted by the UN General Assembly, prompt initiation of a criminal investigation into allegations of torture, particularly where there is access by victims to the investigatory process, in and of itself provides an effective remedy, reparations, and redress. Failure by states to do so results in further injury to victims, eviscerates the prohibition against torture, and may itself constitute a violation of the prohibition, as has been found by the European Court of Human Rights and the Inter-American Court of Human Rights. Fourth, by extension, failure by the pretrial chamber to authorize investigation into this situation as the court of last resort because it found substantial reasons that it would not be in the interests of justice to do so, results in further injury to victims of torture. In this respect, regarding question CA of this chamber's decision on the conduct of proceedings, amici agree with the submissions made by the OPCV and LRV 1 and 2 that the pretrial chamber acted ultra vires in giving itself the power to look for such reasons under Article 53(1)(c) of the Rome Statute. Regarding question CB, amici contend that if this chamber nevertheless finds that the pretrial chamber may consider such reasons, then the chamber erred in its consideration of the factors at paras 91 through 95 of the impugned decision. For the reasons stated by the prosecution and LRV2, those factors were inappropriate because they impinge upon prosecutorial discretion and are in violation of the human right of non-discrimination codified under Article 21(3) of the Rome Statute. Amici add that the pretrial chamber erred in that section as well because it failed to properly weigh, quote, the gravity of the crime and the interests of victims, unquote, as required under Article 53(1)(c). Indeed, there is no reference at all to the per se gravity of torture therein. Further, the chamber's reference to the interests of victims at para 96 as a basis for its conclusion not to authorize an investigation is incorrect as a matter of law. This is because the chamber omitted consideration of the rights of victims of torture to an effective remedy, reparations, and redress, as well as to seeking truth and accountability under international human rights law. Initiation of a criminal investigation into allegations of torture is an international legal obligation and, in and of itself, has reparative effect for victims. Blocking such investigation, on the other hand, purportedly on the basis of victims' own interests, has grave negative effect on torture victims, adding insult and further injury to that which they've already suffered. Consequently, the pretrial chamber effectively closed off the only available avenue for justice left to victims of incidents of torture in the prosecution's request. The Chamber did so, even though, as it acknowledged, all jurisdictional and admissibility requirements under the statute are met. Declining to authorize an investigation because the relevant states refuse to cooperate is not in the interests of justice, but rather supports impunity. In fact, allowing states to get away with not investigating torture and other international crimes by those most responsible turns complementarity on its head. It is precisely for situations like this that the ICC exists. The impugned decision also dangerously signals that power is not bound by law. When it comes to torture, impunity simply cannot be tolerated, particularly with respect to the most powerful countries. The practice of such countries has ripple effects, leading to more torture and undermining of rule of law. As noted previously, when investigating alleged torture in Afghanistan, the prosecutor's strategy would be focused on those most responsible, those officials and policymakers with the power to effect widespread and systematic abuse. This is in line with the court's deterrence and prevention mandates, which are critical for the safety of the dedicated rank and file in militaries and intelligence agencies around the world. Where high-ranking superiors have complete disregard for international law's prohibition against torture and its underlying principle of reciprocity, they put their subordinates at great risk of torture upon capture. Finally, initiation of an investigation by the prosecutor here is substantially in the interests of justice for victims. In response to question C, this chamber should correct the pretrial chamber's error in limiting the scope of the investigation to incidents specifically mentioned in the prosecutor's request and authorized by the chamber, not only because of the reasons stated by the prosecutor and LRV2, but also because this would uphold victims' rights to an effective remedy, which requires a thorough investigatory process capable of leading to identification and punishment of those most responsible. Such investigation will, at last, take cognizance of the claims of numerous torture victims denied and silenced over 16 years. It will also be a critical step toward restoration of their dignity as rights holders. The victims well understand that there is no specific outcome guaranteed by an investigation by the prosecutor. Nevertheless, they overwhelmingly support one. What they are without question interested in and entitled to is a just process, one which states and this pretrial chamber have denied.
Professor Gary, you have 1 minute left.
Thank you. For the foregoing reasons, Amici respectfully request that the appeals chamber reverse the impugned decision and authorize the prosecutor's investigation into the situation in Afghanistan without delay. In so doing, to paraphrase the words of former U.S. Supreme Court Justice Robert Jackson as prosecutor before the Nuremberg Tribunal, the ICC will, by meeting violent acts of torture with an impartial, thorough, and just investigation into those most responsible for international crimes in Afghanistan, help prevent future such acts by cutting short a cycle of violence that was birthed following the tragic events of September 11th, 2001. As a citizen of the United States who cares deeply for its leadership role in upholding rule of international law, not undermining it, I implore the ICC to step in and fulfill its mandate where states have failed to address this vicious cycle. By doing so, the court will play an important role in moving all parties in the seemingly endless conflict in Afghanistan toward a future of healing, peace, and reconciliation. Thank you.
Thank you very much, Mrs. Gary. The global rights compliance to George, you are invited to address the chamber now for the next 15 minutes. Please begin.
Thank you, Your Honor. We submit firstly that the pretrial chamber unjustifiably violated the strong presumption for the initiation of an investigation embedded in Articles 15.3 and 15.4 of the statute. And secondly, we submit that the pretrial chamber's approach impermissibly intruded into the prosecutor's broad discretion under Article 53(1)(c) and went above and beyond its limited scope to review the exercise of that discretion. We submit that in an examination of relevant general principles of law derived from national laws, to which your honours may have recourse pursuant to Article 21(1)(c), further serves to demonstrate the pretrial chamber's errors. In order to assist the appeals chamber in its deliberations, Global Rights Compliance conducted an analysis of the relevant laws and procedures of 51 national jurisdictions. These include both states parties and non-states parties, a range of civil and common law jurisdictions, countries that span every continent. Your Honours have received this morning Annexes 1 and 2 to our submissions. These outline aspects of the laws and procedures that have been assessed. In deference to Article 21(1)(c), we have included those states that would normally exercise jurisdiction over the crimes highlighted in the Article 15 request for authorization, namely the United States, Afghanistan, Lithuania, Romania, and Bulgaria. All these states, all the states we analysed were involved in the drafting of the Rome Statute. Our analysis focused on two issues. Firstly, prosecutorial discretion, with a specific focus on issues related to the interest of justice, or as it is often termed, the public interest. And secondly, the nature and scope of any review of that discretion afforded to judicial authorities. Given this court's particular preliminary examination and investigations regimes, our analysis focused on the exercise of prosecutorial discretion and the interest of justice criteria principally in the context of decisions to prosecute rather than decisions to investigate. The standards that apply to the decisions to investigate under Article 53(1)(c) and to prosecute under Article 53(2)(c) are to be considered as analogous, as evidenced by both the drafting history and the similarity of language used in both provisions. In sum, we found that there are two major approaches within domestic criminal justice systems to the grant and exercise of prosecutorial discretion. States either adhere to the mandatory prosecution principle or the opportunity principle. Consistent with the overriding approach to how the provisions of the Rome Statute were formulated, the ICC system was always intended to represent a marriage of these two approaches. The language of Articles 15 and 53 indicates that in large measure the mandatory prosecution principle was adopted, since it provides for the strongest presumption for the initiation of an investigation within the Rome Statute. The language of Article 53(1)(c) also indicates the adoption of features of the opportunity principle, which provides that the assessment of where the interest of justice lies is within the prosecution's discretion. The pretrial chamber may only review the exercise of that discretion on the most narrow of bases. So I'd like to start by exploring some of the key features of the mandatory prosecution principle, a principle which is chiefly found in civil law jurisdictions. The most dominant feature is the obligatory prosecution of serious offences, encapsulated by way of example in section 152(2) of the German Criminal Procedure Code, which provides as follows: except for otherwise provided by law, the Public Prosecution Office shall be obliged to take action in relation to all prosecutable criminal offences, provided there are sufficient factual indications. And similar provisions figure in the codes of Lithuania, Poland, and Romania, details of which can be found in Annex 1, titles A and B. While prosecutors in such systems are granted a strictly defined residual discretion not to pursue certain cases. By and large, the discretion is narrowly drawn and generally only allows for the discontinuance of cases that are not serious enough to impact on any public interest. For example, Article 171(3) of the Afghan Criminal Procedure Code allows a prosecutor to dismiss a case if the perpetrator's culpability and the consequences of the act are insignificant and its prosecution is not in the public interest. Turning to the second main feature of this approach. Generally speaking, mandatory prosecution systems provide for review of decisions not to prosecute before a superior prosecutor or a judicial authority, particularly when the decision is based on discretionary factors. A typical review power can be found at Section 12 of the Criminal Procedure Code of the Netherlands, which states that if a criminal offence is not prosecuted, the directly interested party may file a complaint against the said decision with a competent court, and similar provisions exist in the codes of Romania and Afghanistan. Bringing this back to the International Criminal Court, it is recognised, for example, in Triftera's commentary, that Article 53 appears in the main to reflect the mandatory prosecution principle. Firstly, Article 53(1) provides that the prosecutor shall initiate an investigation if she finds there to be a reasonable basis to proceed. Moreover, in the case of proprio motu investigations, once the prosecutor conducts a preliminary examination and concludes there to be a reasonable basis to proceed with an investigation, she is obliged under Article 15(3) to request authorization from the pretrial chamber to do so. Secondly, as indicated by the plain language of Article 53(3), the pretrial chamber, congruent with mandatory prosecution systems, also provides for review of a decision not to investigate. The review arises in two distinct circumstances. Firstly, pursuant to Article 53(3)(a), in the case of a referral by the Secretary Council or a state party, a request may be made to the pretrial chamber to review a decision not to proceed with an investigation. As confirmed by the second Comoros appeal decision, upon review, the pretrial chamber cannot order the prosecutor to initiate an investigation or prosecution. However, whilst the prosecutor is obliged to genuinely reconsider her decision in line with the pretrial chamber's interpretation of the applicable law, the discretion remains with her and her alone. Additionally, the pretrial chamber may, under Article 53(3)(b, on its own initiative, review a decision by the prosecutor not to investigate if such a decision was solely based on the prosecutor's assessment of the interests of justice. If the pretrial chamber comes to a different conclusion, it can compel the prosecutor to initiate an investigation or prosecution. To some extent, Article 15(4) creates a divergence from the mandatory prosecution principle insofar as it provides for a residual review of a positive decision to investigate by the prosecutor. However, it should be noted that the pretrial chamber's authority to review is extremely narrow. First, it extends only to proprio motu investigations, and secondly, it is limited to the application of the sensible or reasonable basis to proceed threshold. Consistent with the strongest presumption in favour of investigation, this review threshold is the least demanding within the ICC's framework. If this lowest of thresholds is met, the pretrial chamber is obliged to authorise the commencement of an investigation. Moving on, if I may now, to the second of the two principal approaches, that of the opportunity principle. This is manifested chiefly in common law jurisdictions, although not exclusively, and I would refer your honours to Annex 1, Title C. Countries that adopt this approach do not oblige prosecutors to pursue every case where the evidence points to the guilt of a suspect. Instead, they enjoy a wide discretion in deciding which cases to prosecute. Accordingly, there's a strong presumption in favour of the prosecution of serious crimes where the evidence points to a reasonable prospect of conviction. prosecutors can nevertheless exercise discretion in deciding whether to do so would be in the public interest, taking into consideration a wide range of factors. Secondly, and picking up on a point made by Mr. Maloney yesterday, judicial review of prosecutorial discretion in opportunity principle jurisdictions, even decisions not to prosecute, is available only in the most exceptional of circumstances. The standard of review is very strict indeed. The decision whether to prosecute or not tends only to be reviewable on the grounds of ultra vires, perversity, irrationality, bad faith, oppressiveness, and or conduct that amounts to an abuse of process. As can be seen, these thresholds do not relate to matters of policy and public interest considerations. Returning again to this court, although the ICC system appears to be premised in large part on the mandatory prosecution principle, it contains features that suggest an intention on the part of the drafters to create a practical fusion between the two approaches. Specifically, the ICC prosecutor retains a wide discretion under Article 53 in two important respects. Firstly, in coming to a conclusion on whether there's a reasonable basis to proceed with an investigation. And secondly, in assessing whether there are substantial grounds to conclude that an investigation would not serve the interests of justice. The point has been made, but it bears repeating. Every pretrial chamber authorizing the initiation of an investigation, save for the pretrial chamber in the Afghanistan situation, has to date been consistent in their respect for this broad discretion. The second principal feature is this, that there exists only the most limited possibility for review by the pretrial chamber of the prosecutor's decision to initiate an investigation. While the pretrial chamber may review and invalidate the prosecutor's discretion if she decides not to initiate an investigation based solely on her assessment of the interests of justice criterion pursuant to Article 53(3)b, its authority to review the prosecutor's proprio motu decision to initiate an investigation is extremely limited. And so in sum, if, as we say they did, the drafters of the Rome Statute intended Article 53(1)c to be reflective of features of the opportunity principle, it was also clearly intended that the pretrial chamber would have authority to review the prosecutor's discretionary decisions on interests of justice grounds on only the most exceptional basis. In this case, the pretrial chamber failed to respect both approaches by acting contrary to the strong Article 15(3) presumption in favour of investigation and by overriding the prosecutor's discretion under Article 53(1)c by impermissibly carrying out its own de novo interests of justice assessment. Absent a showing of ultra vires, perversity, irrationality, bad faith, and so on, we submit that it was intended that the pretrial chamber would defer to the prosecutor's discretion. They did not. Moving on to our second main point, and I can deal with it briefly. Even if it is accepted that the pretrial chamber had the authority to review the exercise of the prosecutor's discretion, it abused that.
Excuse me, you have 1 minute left.
Thank you. It abused that authority by not giving sufficient weight to a myriad of relevant and significant factors. Your Honours will see a selection of those factors in our Annex 2. An analysis of the impugned decision shows that the pretrial chamber has failed properly or at all to take into account these other factors, opting instead to erroneously focus on only three: the time that has elapsed, a speculative lack of cooperation, and the availability of prosecution resources. Additionally, we submit that the pretrial chamber irrationally failed to take into account other important factors, such as the need to maintain the rule of law and the level of culpability of the perpetrators of the crimes. To conclude, these omissions ultimately rendered the pretrial chamber's overall assessment seriously inadequate, and consequently legally flawed, such that, had the errors not been made, the investigations would have been authorized. Thank you.
Thank you very much, Counsel. And now I would like to invite Mr. David Schaffer to address the chamber. 15 minutes begins. Please.
Your Honors, may it please the Court, I am grateful for the opportunity to address you today. I bring a perspective drawn from the original intent of the drafting of these documents more than 2 decades ago. Hereafter, when I use the term proprio motu prosecutor, I mean the Article 15 proprio motu prosecutor. When I use the term prosecutor, I mean the prosecutor who acts in response to a referred situation. Pretrial Chamber 2 misinterprets Articles 15 and 53 of the statute and Rule 48 of the Rules of Procedure and Evidence. Its cumulative reading of these provisions in its decision leads Pretrial Chamber 2 to diverge from original intent and distorts how it should be addressing interests of justice. The writings of my French negotiating colleague Gilbert Beatty in this respect, and the amicus brief submitted by Professor Dr. Kai Ambos and Dr. Alexander Heinz of Germany, are recent sources of interpretation that I embrace and strongly recommend be examined. As a drafter, I also found Mr. Tim Maloney's presentation on behalf of the victims yesterday particularly compelling. First, I will answer question CA. There is a clear distinction in the Rome Statute between, first, the proprio motu prosecutor's obligation under Rule 48 to use Article 53(1) criteria in determining whether there is a reasonable basis to request authorization for an investigation, and second, the pretrial chamber's reliance on the same Article 53(1) criteria for review, if necessary, of the prosecutor's initiation of an investigation in a situation that has been referred by a state party or the UN Security Council. Rule 48 is an explicit direction to the proprio motu prosecutor, and only to the proprio motu prosecutor, to incorporate the factors in Article 53(1), paragraphs A, B, and C, in her determination as to whether there is a reasonable basis to proceed with an investigation under Article 15(3). Those factors are vital criteria that should be met, with the final one, paragraph C, being a calculation, if invoked at all by the proprio motu prosecutor, that the U.S. delegation envisioned typically concerned, for example, the operation of a truth commission, some kind of conditional amnesty deal to achieve peace, a justice alternative under complementarity, and/or other options for the victims to seek justice. If the proprio motu prosecutor determined that the Article 53(1)(c) criterion was met, namely that it would not serve the interests of justice to proceed toward an investigation, then the pretrial chamber would not be seized with the issue, because the proprio motu prosecutor, technically at least, would not plead under Article 15(3). That was our intent, to provide guidance to the proprio motu prosecutor in Rule 48 about what she needed to do for an Article 15 exercise. We did not get to that issue in Rome. We addressed it in the rules a short time thereafter, as Judge Prost sought clarification on yesterday. This is the interests of justice determination set forth in the final sentence of Article 53(1) only applies for referred situations by a state party or the UN Security Council. This is because there would not be an Article 15 application to initiate an investigation if the proprio motu prosecutor determined that the interests of justice compelled her not to investigate. The application would not be made because the Article 53(1)(c) determination by the proprio motu prosecutor would have negated the purpose of any request to the pretrial chamber. Of course, the proprio motu prosecutor could volunteer such a negative determination to the pretrial chamber to gratuitously explain why a preliminary examination should not mature to an investigation. But there is no statutory requirement to do so if the proprio motu prosecutor is not seeking authorization to initiate an investigation. Your Honors, the final sentence in Article 53(1) was intended to apply solely to referral situations where the prosecutor would need to inform the pretrial chamber of her negative determination so that the pretrial chamber could review the prosecutor's rationale to cease investigating a referred situation. We knew that would be a controversial moment because the prosecutor would be trying to terminate investigation of a referred situation. So the pretrial chamber would need to step in to evaluate the prosecutor's decision and possibly reverse it. In comparison, the logical procedure for the proprio motu prosecutor is to satisfy the positive criteria of Article 53(1)A and B as the basis for seeking authorization to investigate a situation. The pretrial chamber has no statutory basis for inquiring beyond the merits of those two criteria if the proprio motu prosecutor is not volunteering an Article 53(1)C negative determination. But as Ms. Brady acknowledged yesterday, the pretrial chamber can ask the proprio motu prosecutor to explain how she addressed paragraph C in her preliminary examination. The U.S. delegation was focused on ensuring that the proprio motu prosecutor's powers would be strictly conditioned on obtaining pretrial chamber approval for an investigation of a situation, the legitimacy of which must be argued on jurisdiction and admissibility grounds. Negotiators did not endorse the pretrial chamber standing in the shoes of either the proprio motu prosecutor or the prosecutor following a referral, and then itself initiating a determination that investigating the situation at hand would not be in the interest of justice. Any such power under the Rome Statute would invite the pretrial chamber to unilaterally delve into possibly politically influenced rationales for shutting down the investigation of atrocity crimes. If we had intended such a role for the pretrial chamber, it would have been drafted into the Rome Statute. The original intent of the drafters was that there be no statutory requirement that the proprio motu prosecutor affirmatively stipulate reasons why an investigation would serve the interests of justice. There was discussion based on the original British draft on this point, but the idea was rejected. We recognized that any such requirement would impose an almost intolerable burden fraught with politicized rationales on the proprio motu prosecutor and the pretrial chamber to conjure up any manner of moral and politically acceptable reasonings regarding a prospective investigation. Now I will answer question B. Your Honors, the founding drafters did not define the term interests of justice because it can mean so many different things to so many different prosecutors and judges, not to mention governments. We did not want to open that can of worms, and in doing so, possibly lose the point entirely during the negotiations. If pretrial chamber 2's decision is permitted to stand, it would be like forcing a political leader to explain why she pursues political objectives, or asking a scientist why he seeks the objective truth in his research. That is all self-evident. But grafting it now onto the Rome Statute by adopting pretrial chamber 2's decision in this situation is dangerous. Drafters framed this requirement strictly in the negative because of the obvious purpose of the International Criminal Court, as with credible national courts, to operate within the framework of the interests of justice. Stipulating a requirement that the proprio motu prosecutor and the judges must demonstrate that they serve the interests of justice, or else the request to investigate will fail, would be oddly self-evident drafting, but also invite speculative and politically influenced decisions. Witness paragraph 91 of the impugned decision. Who in the world dreamed up such criteria, neatly framed to obliterate the Afghanistan situation? My goodness, if in the 1990s, when building 5 war crimes tribunals, one had followed the factors in paragraph 91, there would have been no cases and no jurisprudence developed because the arc of international criminal justice is very long and should not be cut off at the knees with such impossibly rigid criteria. Justice is justice. Do not massacre the term with undocumented and highly selective explanations that can only invite allegations of political bias or manipulative pressure from great powers. In the Afghanistan situation, the pretrial chamber overreached without even documenting the basis for its negative determination on interests of justice. It had nothing really to base its assessment on because the proprio motu prosecutor would not have sought authorization to investigate the Afghanistan situation, only to defeat her own application with an assessment that an investigation would not serve the interests of justice. Only the criteria in Article 53(1)A and B are realistically in play when the pretrial chamber judges evaluate the proprio motus prosecutor's application. Your Honors, I want to use a few moments to address some points raised in yesterday's hearing. I think my perspective might be appreciated. First, the impressive representations made by the government of Afghanistan in its brief and yesterday arguing for complementarity missed the point that the International Criminal Court focuses on leadership responsibility for atrocity crimes, while Afghanistan is building a legal system that may indeed bring lower-level individuals to justice someday. But it is implausible for the court to stand down on leadership accountability in Afghanistan, given the ongoing war and political instability and untested resilience of the evolving domestic legal system. The two can run in parallel, with the court focusing on military and political leaders responsible for atrocity crimes, while the Afghan courts undertake the Herculean task of bringing thousands of lower-level personnel to justice. This is how it worked in the Balkans and in Rwanda, for example. Learned Counsel's reference to Article 18 yesterday requires clarification that Article 18, which I had primary responsibility in drafting, only comes into play after an investigation has been initiated, either by pretrial chamber approval of the proprio motus prosecutor's application to initiate an investigation under Article 15, or by the prosecutor commencing an investigation of a referred situation. Article 18 is certainly a procedure Afghanistan can take full advantage of, but first the investigation must begin. Second, Mr. Sekulo's explanation of the American Service Members Protection Act yesterday was incomplete. There has been significant U.S. cooperation in past years with the court because the Dodd Amendment to the Act, namely Section 2015 of the Act, so permits it. But he is correct that when it comes to cooperation with the court with respect to U.S. nationals, the Act does present a formidable barrier. I am more optimistic, however, that one day there will be an administration in Washington that stops being so intimidated by the court, restores the legacy of Nuremberg, along with almost all of its allies, and reasserts America's rightful place as a leader of the rule of law. Third, Mr. Sekulo's reference to the U.S. military justice system as demonstrating that America can take care of its own is a point I repeatedly made in the 1990s in the negotiations when I pressed the complementarity argument. Unfortunately, that point has been soiled recently by the U.S. President's appalling interference with several cases in the American military justice system. I doubt many outside the United States would be impressed with the point anymore, which is unfortunate, as the JAG officers and others whom I have known and worked with through the years in the military, who uphold the highest standards of conduct under international law, are to be respected for their integrity and enforcement of the Uniform Code of Military Justice. And yet leadership flows from the top, and right now it is not a very honorable outcome. I fear it will now take many years to restore the credibility of the argument. Fourth and finally, Mr. Sekulo's very able argument regarding the posture of non-state party nationals under the Vienna Convention in respect of the court's personal jurisdiction is one I know well. I argued it as a negotiator and ambassador in the 1990s, but it was a policy statement that followed the Rome negotiations, one that I introduced before the American Society of International Law as an official position in early 1999. So it really was not an explicit component of original intent in the drafting of the Rome Statute. It also gained little traction either with governments party to the Rome Statute or in academic circles. I find it now a rather retrograde
Professor Schaefer, you have 2 minutes left.
Okay. I find it now a rather retrograde rationale for bailing out of the quest to end impunity for atrocity crimes. It is an argument that flies in the face of one of the most fundamental rules of criminal law, namely territorial jurisdiction, and defies common sense regarding atrocity crimes, some of which indeed have entered the realm of jus cogens, as Judge Carranza rightly pointed out yesterday. I do believe there was a sloppiness that emerged in the rushed final draft of the Rome Statute on July 17, 1998, that presents an interpretative dilemma for the court on this matter. And I point you to my 2002 article in the Cornell International Law Journal and my 2004 article in the Journal of International Criminal Justice, as well as my book, All the Missing Souls. The basic point is that one of the principles we operated under in the negotiations leading to the Rome Statute is that a state's conduct and that of its nationals for purpose of international criminal justice, prior to becoming a party to the Rome Statute, would not be reviewable unless Article 12.3 were activated. This would incentivize universality of membership by encouraging states to enter the treaty without fear of ex post facto justice over its nationals and its own conduct. There may be some merit for the court to examine this issue in the Afghanistan situation, including the cluster of treaties referenced by Mr. Sekulow, and settle this legal issue once and for all. The Myanmar, Bangladesh matter and others will increasingly bring the issue of non-state party nationals to the fore in the practice of this court. So, the appeals chamber should reverse the pretrial chamber's decision on interests of justice, and upon review of the pretrial chamber's own evaluation of jurisdiction and admissibility, authorize the investigation of the Afghanistan situation to the extent that the appeals chamber decides that it meets jurisdiction and admissibility requirements. I have a couple of other proposals for the future, but I'm open to those in the questions.
Thank you, Mr. Schäfer, very much. We will adjourn now for half an hour. We will meet again 11:45.
All rise.